How long can a traffic stop last? Are there any restrictions on what police officers can say or do during a traffic stop? On April 17, 2019, William Claver was driving south towards Chattanooga, Tennessee. Police officer Daniel Wilkie, a Hamilton County deputy sheriff, stopped Claver for a tinted window violation. The driver didn't know it at the time, but he was facing a police officer described by the New York Times 7 months later as having been charged, quote, with rape, extortion, stalking, and assault, as well as false imprisonment, child molestation, and forced baptism.
Was that wrong? Should I not have done that?
Yes, that's right, forced baptism. And there's video, believe it or not. Welcome back to the Civil Rights Lawyer channel. This video began as just being about a traffic stop that occurred to William Claver in April of 2019. But the officer involved here, Deputy Daniel Wilkie, well, former deputy, is really an insane story just in and of itself. This may be the only officer I've ever heard of who is forcibly baptized an arrestee, among multiple other allegations. Much of his misconduct has been caught on video. But first, let's look at the April 17, 2019 traffic stop with Mr. Claver that would find its way to the Sixth Circuit Court of Appeals. There, the court examined the issue of whether police officers could prolong a traffic stop to have a drug dog arrive and sniff for drugs. How long can police officers hold a driver at a traffic stop? When and for how long can they prolong the stop under the Fourth Amendment? After stopping the driver and approaching his window, Wilkie told Claver that he stopped them because his windows were, quote, way too dark and requested his driver's license. That was at 8:10 p.m. As Claver searched for his license, Wilkie then inquired about where Claver was headed. When Claver didn't respond, Wilkie asked, "Not going to talk to me?" At about this time, police officer Tyler McRae, another Hamilton County deputy, pulled up and approached the vehicle's passenger side window. After several seconds, Wilkie asked Claver, "You okay?" and again requested his license. Claver then asked, "Am I being detained?" Wilkie responded, "Yes," after which Claver handed over his license. The Fourth Amendment prohibits police officers from prolonging a traffic stop beyond the time necessary to investigate and write a ticket for a traffic violation unless the officers have reasonable suspicion that the stopped vehicle's occupants are engaged in some other crime. That's Rodriguez versus United States, 2015 U.S. Supreme Court. Officers may detain the driver only for the time necessary to complete the tasks associated with the reason for the stop. The Supreme Court has provided a list of acceptable tasks that are connected generally to safety and driver responsibility. Officers will usually question a driver about the traffic infraction. They will run the driver's license plate, they will request and review the vehicle's registration and insurance information, they will check for outstanding warrants, and lastly, they will write a ticket. Officers also commonly question drivers about their travel plans. So long as they do that during the time that they undertake the traffic-related tasks for the infraction that justified the stop, officers may also ask questions about whether the driver has drugs or weapons in the car, or even walk a drug-sniffing dog around the car. These unrelated tasks turn a reasonable stop into an unreasonable one if it prolongs the stop. The reasonable suspicion basis for the traffic stop detainment here was an allegation of dark tint. Later, the officers would argue the existence of other criminal suspicion, including suspicion of Claver being a, quote, sovereign citizen, and Claver visibly shaking. This, they would argue, justified the officers suspecting Claver of being in possession of drugs. As Wilkie and McRae headed back to Wilkie's cruiser, Wilkie said the words sovereign citizen to McRae. The officers then talked. Wilkie observed that Claver's van had an obstruction, as he called it, which was a Marine Corps sticker over his license plate. He also claimed to have noticed that Claver was, quote, shaking like a leaf. He told Deputy McRae that they should, quote, make sure he ain't got no pot or anything. Wilkie suggested that they call for a drug-sniffing dog. So about 5 minutes into the stop, the officers returned to Claver's van and requested his registration and insurance card.
Mr. Claver? Do you have your registration, proof of insurance with you also?
Proof of insurance?
Yes. Also, sir, I don't know if you know the statute for improper display. You can't have any kind of foreign matter or material on top of your tag, okay? The Marine Corps sticker. I appreciate your service. I was in the military also, but you can't have those stickers on your tag, okay? It's against the statute. Wilkie, I lost my tag. I was in a wrestling match with somebody and my tag broke off. Wilkie, 3099 if you need that. I'm also recording you.
You're a Wilkie.
Yes, sir. You know any Wilkies? Alright, you gave your an insurance card with you?
It's on my phone.
It's on your phone. You can take it down if you need to. That's fine.
Wilkie continued to question Claver. He asked him whether he had ever been arrested, whether he was on any kind of medication, or had any kind of disability because, he said, you're shaking. Did the deputies have reasonable suspicion to prolong the stop? To have reasonable suspicion here, the deputies needed a particularized belief, and that is one that's tied to Claver, and an objective belief, and that is one that's tied to articulable facts rather than amorphous hunches, that Claver possessed drugs. The court looks to the totality of the circumstances. The Sixth Circuit here rejected the officer's claims that Claver might be a sovereign citizen solely because he asked if they were detaining him. They noted that the video showed that Claver was reasonably polite, not loudly confrontational. Unless everyone who is reluctant to speak with the police might be a sovereign citizen, the deputy's claim appears to have rested more on a subjective hunch than objective facts. The court noted that the officers failed to identify a single judicial decision or evidentiary citation suggesting that a person's, quote, sovereign citizen status correlates with the likelihood of possessing drugs. At 8:18 p.m., now 8 minutes into the stop, the deputies returned to the police cruiser and requested a canine officer. Dispatch informed them 2 minutes later that one was en route to the scene. Wilkie then filled out paperwork for the traffic ticket over the next several minutes. At 8:24 p.m., McRae approached Claver. A few minutes before, Claver had begun recording video of himself from inside his van. He filmed himself peeling the tent from the inside of the driver's side door window.
Again, I refused them permission to search my vehicle.
McRae attempted to ask him about his military service. Claver responded that he didn't mean to be disrespectful, but that he would not answer any more questions.
Hello. I see all the Marine Corps stickers. Was you in the Marine Corps? Did you retire from the Marine Corps?
I'm not going to answer any more questions, okay? I don't mean to be disrespectful.
You're fine, buddy. You ain't disrespectful to me. You're all right. I just seen the Marine Corps stickers. I just wanted to inquire about that.
Yes, I'm a veteran.
Are you? Well, appreciate your service.
Thank you.
You don't want to talk to me about how long you served or anything? You don't want to talk to me about how long you served in the Marine Corps? How come?
If I'm not being arrested, I'd like to be on my way, okay?
Well, he's writing you a ticket right now.
Okay.
So.
Well, then, unless I'm being detained, if I'm being arrested,
well,
you need to read me my rights, or you need to let me go.
According to the Fourth Amendment, you're detained whenever the blue lights come on. So.
Deputy Wilkie continued filling out the ticket until the canine officer arrived at 8:32 p.m. Wilkie then returned to the van and ordered Claver to exit the van for the dog sniff.
Mr. Claver?
Yes.
All right, sir. Salt Daisy PD is here. They have their canine. We're going to have you do step out of the vehicle. I'm going to have you come back here and sign the citation. He's going to run his canine around your vehicle, see if it detects any kind of narcotics or anything like that. If he does detect narcotics inside your vehicle, we're going to search your vehicle. We'll see what's inside of it. But at this time, I need you to step out for me so you can come back here and sign my ticket, and that dog can run around the vehicle.
Let me roll that up, keep the bugs up.
Yeah, that's fine. You need that cane?
Oh, not yet.
Okay. Just go right back here.
So now it's 8:40 p.m. Deputy McRae told Wilkie and an incredulous Claver that the dog had alerted to drugs inside the van. McRae and Wilkie then searched the van for 5 minutes.
that thing rattle.
Got me excited.
Quite a chance.
We're probably still recording. So.
Yeah, I know.
They found nothing. As Claver signed the citation, he said to Wilkie, "In case you were wondering, I have muscular dystrophy." Wilkie replied, "That's all you had to say, sir." Claver then drove off. It was 8:50 p.m.
Y'all see that? Y'all were in here had a first roast.
Mr. Claver filed a pro se lawsuit against Wilkie and McRae, among others. The defendant officers moved for summary judgment. The court denied those motions on the ground that the officers unreasonably prolonged the traffic stop without reasonable suspicion that Mr. Claver possessed illegal drugs. The defendant officers filed an immediate appeal on qualified immunity grounds. The Sixth Circuit issued an opinion that just came out on November 3rd, 2022. In the end, the Sixth Circuit held that a reasonable jury could find that both Officer Wilkie and McRae unreasonably prolonged the stop. So the Sixth Circuit upheld the denial of qualified immunity to the officers, noting that, quote, "We have a mountain of case law indicating that heightened nerves represent weak evidence of wrongdoing and cannot be the primary justification for a stop." Okay, so then the aftermath of Deputy Daniel Wilkie. A New York Times article, December 11th, 2019, comes out. Tennessee Sheriff's Deputy indicted on 44 charges, including rape and stalking. Daniel Wilkie was charged on Tuesday with rape, extortion, stalking, and assault. Has previously been accused in lawsuits of false imprisonment, child molestation, and forced baptism. So just a crazy, crazy story came out detailing all of the charges of misconduct and the lawsuits against him. So December 27th, 2019, he resigns. And then there is another lawsuit that's filed that comes out over this forced baptism. That ended up winding its way through the federal courts, ended up in just a bizarre federal court order. There's also accompanying video footage that is showing this incident, this incident of forced baptism.
Believe that Jesus Christ died on the cross, raised from the dead 3 days later. You said that? For the Father and the Holy Spirit, I baptize you.
And unfortunately, it's just too much to get to in one video. Make sure you subscribe so you can catch part 2 of the saga of Deputy Wilkie. How long have you been held at a traffic stop? Let me know in the comments. Remember, freedom is scary. Deal with it.